Okay, good morning, ladies and gentlemen, dear colleagues and friends. So my task is to talk a little bit about the US teaching and legal studies, because I have been sometimes in the US, mostly in South Texas, San Antonio. And of course, I'd like to compare that a little bit with the legal study and teaching I know, which is mostly Austria and Germany. So if you have any additions from your home education, it's of course welcome for the discussion. So I have 4 parts. The first part is the preparation for the legal studies. The second part will be the exams. Third part will be the teaching methods. And the last part is the assessment of the students, so the grading, of course. So if you look to the USA in the preparation for the legal studies, there's a big difference to most European countries because the law school education is a graduate degree program. So before entering the law school, the students have to have an undergraduate study, mostly 4 years in any arts or science. So when they go to law school, they of course mostly older than our students, and they have insights into academic education. So this is not what we have, for instance, in Austria and Germany. So directly our students are coming from high school. They are undergraduate students, and of course that makes a difference. And the second thing is that if you want to go to a law school in the USA, you have to have an examination at the entrance. So there are admission rules for all law schools. If we look, for instance, to Austria, we have the system of free education, university education. So everyone with a matura, which is a high school degree, can study mostly any study he wants to. There are some exceptions like medicine or psychology, but for instance, law, we should take all from high school. This is a little bit different in Germany because if I'm still correct, there is the grades from the high school. There is some admission process on that still. Friedrich, okay, yeah. So except for some private law school, so for instance, in Germany, we have Bucerius in Hamburg, they have admission tests. And of course, they can say, okay, we only take the best students or the best high school students coming to us. And of course, that makes an effect on the grades. So Bucerius had mostly the best grades in the examinations. So to sum that up, in the US, you have to have 4 years college, undergraduate, and then you study 3 years at the law school. In Germany, you study, I think now 5 years. I think it's 2019. Before it was 4 years. So in Austria, you study 4 years. If you have a bachelor master program, like we have in Innsbruck with business law, you study 5 years. So there is a difference, of course. And of course, in the US, you can have the bar exam after the exam at the law school. Then you can directly be a practicing lawyer. In Germany, you have to take the Referendarzeit, the internship, mandatory for 2 years. In Austria, you have to be 2 years of 3 years in a legal office and then make another exam to become a practicing lawyer. So of course, there are some differences, and I think if we look to Italy or Greece or Portugal, there are some other differences. So this is about the preparation for legal studies. Next, we have the exam. I said that bar examination is the main standard. The American Bar Association gives the standards, and the students have then to pass the bar exam. Now it's a little bit easier to have a unique or a uniform bar exam for several states. Before it was only for one state. So you make this bar exam in Texas, you are only able to be a lawyer in Texas, not in New York or not in California. Now that's a little bit more easy. In Germany, you have to have the first state exam at the university, and then the second state exam after the Referendarzeit, after the internship. In Austria, we have the diploma still, sometimes bachelor master, and the second practical exam to go to a legal office or to become a judge or some other civil servant. And if you look to the content of the exam or of the studies in the US, there is less specialization than we have in Europe. And there's much more trial advocacy, moot courts, legal clinics, and other things. So US students are more trained in oral things. So what I think is missing a little bit in Europe. So legal clinics, for instance, the students engage in pro bono representation of persons from lower socioeconomic status, and they help them in various legal issues. Moot courts, of course, you know, so we have some moot courts, but in the US, moot courts are mandatory for all students from the first year on. So every student have to have, let's say, 4 or 5 moot courts. Then the teaching method, of course, that is what normally makes a difference, because in the US, you have heard about the Socratic method, so that the students have to read mostly a case before the class, and the lecturer then will call the students randomly by cold call. So not if they sign up, but okay, Mr. So-and-so, Mrs. So-and-so, what do you think about the case? So that's, of course, another thing than we have in our mostly big room lectures in front of 100 or 150 students, or maybe 50 or 70. And of course, the lecture method is combined with the group size. So in US law schools, you rarely have groups with more than 30 students. Maybe in the first year, you have some bigger groups, but of course, the groups are smaller than we have that in Europe. And of course, that makes it possible to do that Socratic method. It's not possible to do that in a big room with 100 students. So, of course, the Socratic method makes sense because there is a dialogue between the students and the lecturer. And I think it deepens the learning of the students. So if you only listen to something, well, after you go out of the room, I think 2/3 of that is forgotten. If you have to think about and prepare your answers, that's of course much more effective, I think. So that, of course, is a big difference. Of course, every law school has its own attendance policy, but normally there are strict rules. If you are 3 times no show at the lecture, you are out. Your course is not graded. So that is what we don't have normally. In our lectures, we don't have mandatory attendance. We have that in practical courses or so, but not in the lectures. So then last but not least, the assessment of the students. So in the US, the teachers try to orient the assessment and the grading to the students, and they have exams on the course. So this is, of course, very different from the German education, where you have at the end of your studies a final exam for all courses, for all topics. And that's, of course, something which makes the students, they have a little bit of fear of that examination. So, and the other thing is that, of course, because the US is mostly, except Louisiana, as we know, the common law system, the students are trying to work with cases, case analysis, and other things. Of course, we do that in Germany and Austria, that we let's say, solve the students' cases. But this is another thing, because we can rely on our acts and statutes. In common law system, of course, we have to know what the courts are saying. So that's, of course, different. So there are a lot of differences in these 2 types of education. So let's say the European one and the US one. But finally, I'd like to show you that there was an attempt to have some of the aspects of your teaching in Germany, because you may know that from 1970 to 1985, I think, we have the so-called single-phase legal education as a reform study. And in Hanover, it began in 1974. And I'm one of the students who studies this single-phase legal education. And single-phase means that you integrate the referendar side, the internship, into the study. So we studied for 2 years, and then we went for 1 year to practice. And we studied another 2 years, and then we went again to practice. So not 2 phases like now or before, but integrated study phases. And the second thing was that in our studies, we have groups with not more than 25 to 30 students. And we have to read a lot before the course. So we got reading material of, let's say, 30, 40 pages for every hour of course. So we can discuss the things with our lecturers. And that, of course, is something like the Socratic method in the US. So this reform education, of course, was stopped. I think political reason, because it was a thing from social liberal government, and then the conservatives then come in 1980s. And of course, it was a little bit more costly than the normal legal education, because you have to have lectures for all these 25, 30 groups, person groups. But I think we have to think about if this is not more effective than the legal education we now have, with big classes, with frontal lectures, and all the other things. So that's my talk for today. Thank you for listening, and maybe we can have discuss.